Hello friends, I welcome you once again. Today the topic of discussion is an interlocutory order which could be passed by the court in order to do the complete justice at any stage of the case or the suit. Now herein I need to use a word suit because we have been talking about a civil law. See, Order 38 Rule 5 which carves out a provision to attach somebody's property before delivering the judgment. The basic object of this provision is to secure the interest of the plaintiff so that in case the decree is passed in his favor, he should be able to realize the fruit of this decree. Now, he has to establish cogent reasons, prima facie cause of action and solid ground. He cannot come to the court of law and talks in air that sir, defendant is going to dispose of the property from the ambit of this court, then the property should be subject to attachment. Court will merely not do so because it is a very drastic order. Apart from financial stake, one's emotions are always associated with the property. When it comes to Indians, they are so sentimental and they are so attached to the property and they really want, they should not be restrained to deal with their property in any manner. They have to have a full command authority to dispose of or to possess or to enjoy the property. So this is not the power which is to be exercised by the civil court in a routine manner. Rather, it has to be exercised sparingly, exceptionally, and when the situation so warrants. Order 38 Rule 5, no doubt, safeguard the interest of the plaintiff, but also protect the property of the defendant when it comes to strike balance between the interest of both the parties. So my dear friend, it is not an automatically an application would come and it would be decided positively by the court and property would be subjected to attachment, but the plaintiff will have to prove his case which actually prompt the court to pass such a drastic order. Now 38(5) provides two conditions which are required to be complied. One of the condition is the detail of the property is required to be mentioned and the court should be satisfied subjectively that yes, the defendant is about to remove or dispose of the property from the power, jurisdictions or the ambit of the court. If court gets satisfied, then only such an order could be passed. Now, after a decree, there is a provision of attachment under the chapter execution which clearly lays down that if the judgment debtor is running away or not complying with the decree in its letter and spirit, then those powers could be exercised. But herein the decree is yet to be passed. So the court should believe or has a subjective satisfaction to this fact that yes, ultimately the plaintiff would succeed, and because the contentions and the governments are in favor and the defendants, see, court here can do one thing, conduct of the parties before presenting the suit can also monitor, fine, or if court feel the document produced really satisfy the existence of prima facie case, then court will examine and interest of the plaintiff would be protected and ultimately the order would be passed. See, herein you need to understand one thing, that property which is going to be attached is not a subject matter of a suit. Now, if had it been the subject matter of the suit, then injunction could be sought to put stay on the alienation or disposing it off, fine, but herein the property is not the subject matter before the court, meaning thereby if somebody has instituted a case to claim damages, or it's a suit for specific performance, or it is a suit for say obtaining the money decree, these kind of suits, but the person, the defendant concerned has a property otherwise, then in order to secure the interest, or you could say in other words that it is sort of a guarantee of assurance which is given by the court to the plaintiff after considering or after appreciating the facts and the evidence on record that yes, your interest would be secure and ultimately you could realize the fruit of the decree from the property. So attachment here means the seizing of the property through a legal process to secure the interest when court feels that yes, a prima facie case is made out in favor of the plaintiff and defendant is likely to obstruct the cause of justice. So just in order to prevent the cause of justice not to be defeated, this provision has been worked out. Few more points which you have to remember, since I said that initially that it is an interlocutory order. Section 94E, power of the court to make interlocutory order after suit is filed and before it's finally disposed of. So court is empowered under Section 94 to pass interlocutory orders such as order of injunction and order of attachment before the judgment. And last, I will just sum up and you can make out a point. Now, see, it's a question of fact. The circumstances which lays down under Order 38, Rule 5 are a question of fact, and these must be proved to the satisfaction of the court. Court would not be justified in issuing an order merely because if things fit that no harm or prejudice would be caused to the defendant. One more thing which you have to keep it in mind, that transactions with regard to the property before the institution of suit, those are not to be taken into consideration, because court cannot look into it. Court can only look into the conduct of the parties immediately before the suit to examine the surrounding circumstances or to draw an inference whether the defendant is likely to or really going to dispose of the property in questions in order to defeat the claim of the plaintiff. So these are the things which court have to monitor. So my dear friends, I think I have been able to clarify the concept, and see you in the next lecture with a new concept. Thank you very much for hearing me patiently.